Fourthly, the legislation continues to exclude many disabled people from jury service in a discriminatory manner. Section 82 is highly problematic and discriminatory. While it recognises the right of deaf people to sit on juries, it goes on to exclude other whole cohorts of people. It introduces the paternalistic language of sufficient mental or intellectual capacity. There is even a typo in the actual bill where it says incapacity, which in that context just doesn't make any sense. This language is inconsistent with the 2015 Act, which deliberately does not include any reference to specific cognitive impairments. Disabled Women Ireland pointed out that this type of language focuses on the person's impairment and how it may be difficult for them to participate, and it does not recognise or place any onus on the state or the court service to reasonably accommodate them to participate. This paternalistic and medicalised model of disability, focusing on incapabilities rather than putting forward progressive laws and associated supports to assist disabled people to participate in juries, has to go. Serving in a jury is a civic responsibility in our republic. It will exclude whole cohorts of people. As was said at yesterday's briefing, many people try to get out of jury duty, and there are many disabled people who want to serve. Instead of empowering these individuals, the bill intentionally excludes them. Back in 2013, the Law Reform Commission report suggested much more inclusive and progressive language. This is the type of approach we should be pursuing. A final point on Section 82 is its implications around mental health, which are disgusting. It excludes a person, and I quote, who suffers or who has suffered from a mental illness or mental disability, and on account of that condition, either A, is resident in a hospital or other similar institution, or B, regularly attends for treatment by a medical practitioner. That is highly stigmatising language. Anyone who has or has had a mental illness and saw a doctor several times about it could be excluded from jury duty. On what basis? How are we even talking about such a thing? How can it be considered in 2022? Finally, there are several issues that I can only mention briefly in the time that I have, but need attention. The removal of treatment decisions from enduring power of attorneys and forcing people to create a separate advanced healthcare directive instead creates additional complications and barriers. Disabled people organisations, legal experts, advocacy organisations and others argued that this would be less accessible, more complex and insufficient. There are outstanding issues around involuntary detention highlighted by mental health reform. As the legislation stands, people who are involuntarily detained do not have the right to have their advanced wishes about treatment respected, even though they had capacity to make decisions about their mental health care and treatment at the time of making their directive. There is no other group of individuals that are specifically excluded from this legal right. This exclusion is contrary to international human rights standards. Also, it was highlighted during pre-legislative scrutiny that family carers are being treated differently to decision-making representatives appointed by the court. Those appointed will receive expenses and remuneration, but this provision has not extended to carers. This is another case minister of the state taking family carers for granted. The committee heard the challenges carers face in terms of how little support is offered by carers allowance and the conditions around qualifying. Then there is the bizarre requirement for the Irish Human Rights and Equality Commission to engage with the National Disability Authority in carrying out its monitoring role under the UN Convention, rather than mandating the Irish Human Rights and Equality Commission to engage with disabled people's organisations. The National Disability Authority is not a DPO, it's not a disabled persons organisation. The bill is specifically requiring IREC to engage with organisations other than those representing disabled people. I've touched on some of the major issues with this legislation, but even more significant is the unknown issues. Because the Department and the DSS have not meaningfully engaged disabled people, older people and people with experience of mental health services, there are potentially significant matters which we are still unaware of. That is the practical purpose of Article 4 of the Convention on the Rights of People with Disabilities to make laws informed by those who it will affect the most. Instead, this breaches the rights of disabled people. The people it will affect the most have been excluded. There is still time for the Minister to do the right thing and to halt the process until adequate consultation has occurred. This legislation will have far-reaching consequences for whole communities of people. It will be the subject of litigation and human rights challenges, all of which could be prevented if the government adhered to its human rights obligations by respecting and engaging with people affected. Again, I'm going to quote Joe McGrath of the National Platform of Self-Advocates. Not only does he have a better understanding of the Convention than the government, but he sums up the issue very well. Let's get this legislation right so we don't have any constitutional challenges. We're the ones who are going to have to live with it. I cannot implore you enough, Minister, to halt this deeply flawed and potentially dangerous situation and just listen to those lives who will be shaped and limited by this legislation. Nothing about us without us.